And I'll deal with them in reverse order, if I may. First, on the oral hearing piece. So the approach adopted in the bill, as the Senator Martin has said, is that, and is based on the advice of the Office of the Attorney General, is that the bill is that it's not required to hold all of the hearings in public. There's no responding party, and so it would just be the person under investigation before the Commission. And the basis for this, as the Senator will be aware, is the Supreme Court decision in the Zelensky case in 2021, which related to the exercise of powers by adjudication officers in the Workplace Relation Commissions. And Justice O'Donnell, in that case, stated regarding the issue of an oral hearing, the rule is, quote, the rule established under the Constitution is not an absolute one, even for court proceedings, and is not expressly required under Article 37 in respect of the adjudicative processes covered by it. There is a justification for calm, quiet and private resolution of many disputes, which may be of particular sensitivity for the participants, as you've referenced, Senator, and it may even be permissible to have a presumption in favour of private hearings at first instance, but it is not, in my view, possible to justify the absolute ban contained in section 4113, referenced in that case, particularly when on appeal the opposite provision is made. The AG's office advised, therefore, that there is no necessity to provide such oral hearings be held in public. Additionally, there is currently no prohibition on such hearings being held in public in the Act or in the Bill. As you've said, the balance is such that that it can happen. From a practical point of view, it occurs in most cases a person subject to an administrative sanction procedure would probably prefer a hearing to be held otherwise in public, and SIPO may have a similar preference. But permitting them to be conducted in a private setting in the first instance, i.e. before SIPO, may tend to facilitate the more efficient running of such hearings. And indeed, in the words of Justice O'Donnell, there is a justification for calm, quiet and private resolution of many disputes, which may be in the interests of both parties. So that is the justification for that approach, having regard to the recent Supreme Court decision. In relation to the oath, the administration of an oath and/or affirmation, there's a pretty technical, academically interesting but technical justification for why affirmation isn't also necessary. Going back to the Oaths Act of 1888, I can provide that to the Senator if that's more efficient and more desirable, but essentially the advice is that it's essentially not necessary, having regard, going back through the Interpretation Act of 2005, having regard to the earlier 1888 Act, it is essentially the same thing. And having regard to and I'm happy to provide that to the Senator should it be of interest to him. Finally, the piece around the criminal and civil sanctions and how that operates and how the interplay of those two things. It is only just for the failure to register or failure to make returns, as I understand it, but the real balance is that the criminal proceedings would take precedence. It's up to SIPO to investigate and make a determination about its view of the seriousness of a particular matter. If there's any question about it being at the criminal level, it will simply pass it on to the relevant prosecuting authorities for criminal prosecution, and any civil sanction or any other sanction would be simply paused in the event of that. SIPO is a quasi-judicial body, as you've said, but it's very conscious of infringing on the jurisdiction of the court in relation to any criminal matter. So it's up to it to make a determination as to which body, which prosecuting authority or which process would be appropriate. And as I said, it would firmly step back in the event of any criminal matter. I hope that answers it for the Senator.
Thank you, Minister.